The Vian City Attorney said he dropped the charge because there was no apparent probable cause to initiate a traffic stop, which resulted in a city councilman's son being arrested. But citing this Supreme Court ruling, an assistant professor for legal studies says there may have been enough reasonable suspicion for that driver to be pulled over. May 2nd, this body cam footage shows Officer Lindsey Green conducting a traffic stop.
You got your license on you?
I got it on me now.
Are you still suspended?
For me?
Yeah.
Shouldn't be.
Class D, revoked.
After checking with dispatch, Joshua Smith was arrested for driving with a suspended license, but his charge was dropped by the city attorney. In a press release sent to us Monday on behalf of the town, City Attorney Larry Vickers said, quote, "A report that a driver's license was suspended in the past is not enough to justify conducting a traffic stop without verification that the license is currently suspended. Officer Green could have simply checked the status of Smith's license with dispatch and confirmed whether Smith's license was valid or suspended. She did not do so prior to stopping and detaining him. But did Officer Green legally have a reason to make the traffic stop?"
It's an interesting question if they were in the right. And there is some Supreme Court case law that talks about when a tip can be enough for an officer to pull someone over.
The assistant professor for legal studies is referring to Navarrete versus California.
And that case kind of sets the goalposts on the issue of reasonable suspicion.
The Supreme Court ruled in 2014 that police had reasonable suspicion to pull a driver over based on a 911 call that the driver ran someone off the road.
What the court said in Navarrete was, what you need are some indications that this tip is reliable.
According to the police report, Green was called by an off-duty officer who saw Smith driving in front of the officer's home. The report shows in November that off-duty officer also wrote Smith a ticket for driving without a license.
You know the veracity of the person. We tend to think of law enforcement as being people who would speak the truth that they're going to bother to call it in. Reasonable suspicion is enough to stop. And during that stop, it has to rise beyond reasonable suspicion to something like probable cause before an arrest could be made.
And today I made the Vian City Attorney aware of this Supreme Court ruling, and by phone he told me that he did review it today, but he says he still stands by his decision to drop that charge of driving on a suspended license. Live in Vian, Brett Rains, 4029 News.